One of the reasons is under what's called a force majeure clause, which is, and that's a clause which essentially says if there's a supervening event or an act of God, or something similar like that, then you can either suspend your rights under a contract or a lease, or it can sometimes cancel it. Now, the Auckland District Law Society doesn't have, as a standard term, a force majeure clause. So that means that a tenant cannot cancel on that basis. The other ground that people sometimes claim is it's called a frustration of contract. Now, that is available technically to leases, but the House of Lords have said that it will very, very seldom be available. And our view is that frustration, a lease cannot be frustrated and therefore cannot be cancelled because of this current lockdown that we're in. So the general position is that a tenant cannot cancel the lease because of this lockdown period. Now, I will now take you back to the events of February 2011 in Christchurch, when we had the Christchurch earthquakes, which have kind of tested this scenario out a little bit for us. So when those earthquakes happened, the lease dealt with, the ADLS lease deals with damage to property and what happens and when a lease might be terminated then. But it never contemplated the fact that you might have properties which have no damage at all but are sitting in a red zone like we saw in Christchurch. So what happened then, the Auckland District Law Society in 2012 published a new version of the lease, which actually dealt specifically with that no access. And what that lease does is it allows, when you're negotiating the terms of a lease, it allows you to put a period of time in there in which, if a tenant cannot access the premises, they're entitled to cancel. So the default provision is 9 months. So you have to wait 9 months before you can exercise that right if you're a tenant. People generally change that depending on the term of the lease. So, for instance, I had a client last week who had 2 months in there. So if after 2 months she is still not able to access her premises, then she can actually cancel her lease. So please note that this no access provision only relates to leases which were signed after 2012 and have that provision in them. Otherwise, a tenant does not have a right to cancel using that clause. The last thing I just briefly want to touch on cancellation is we have a lot of people that are on what's called a statutory tenancy, where, for instance, if they don't have a written lease, or their lease term may have come to an end and they are still occupying the premises. So what happens in that scenario is the tenant can give notice with 20 working days prior notice to bring their tenancy to an end. So that is also an option for tenants. But I would advise you strongly to speak to your lawyer about how you bring the tenancy to an end, because you have to follow the procedures correctly to avoid any adverse consequences. So that's cancellation. Now I just wanted to talk about probably the hotter topic, which is what happens to rent and outgoings. So again, it depends on which version of the ADLS lease you have. If you've got the pre-2012 version, there is no right for a tenant to pay a reduced rent during that period. And this was the case in Christchurch during the earthquakes. What the experience in Christchurch was that actually landlords were fairly generous, and it wasn't often that tenants did have to pay rent. Now that was a little bit unique in that circumstance because landlords could claim loss of rent insurance. Now, I understand that loss of rent is not going to be available for this current lockdown, and that's because generally pandemics are excluded from most insurance policies. So, it remains to be seen as to what landlords do, but yeah, the landlord still does, as a matter of law, have the right to ask for all rent and outgoings be paid if they have a pre-2012 lease. Now, again, we've seen some particularly large multinational tenants in the last week just be quite bolshy and just tell our landlord clients they're not going to pay. But again, the legal position is the landlord does have a right to that and they can recover it. And obviously that feeds through to personal guarantees as well if a tenant's given one of those. So now turning to the Auckland District Law Society provision in 2012. So from that time onwards, there's a clause called Clause 27.5 in the lease, and it would be unusual for that lease to be amended too much during the negotiations of a lease. It's a fairly standard sort of clause. And what that clause says is that if there is an emergency, and that definition of emergency is quite widely drafted, and it certainly this current lockdown certainly fits that criteria, particularly given that there's some legislative basis for lockdown now under the Section 70 of the Health Act, and the tenant is not able to access the premises. So again, it's important to note the distinction between an essential and a non-essential business. So for instance, if you're a supermarket and you're still operating your business and you're probably doing quite well at the moment, then you are able to access your premises and this clause will not apply. So it's only for those businesses that are not essential that have had to close their doors. So if it's an emergency, you don't have any access, and for reasons of public safety, that's why there's no access, because of public safety concerns, then the tenant only has to pay a fair percentage of rent and outgoings for the period during which they can't access the premises. So what is fair? That is a question. So there's no the courts haven't given us any guidance about what's fair. And I've had a discussion with a number of colleagues, and we sort of there's varying opinions, but generally speaking, I expect a fair reduction to be between at least 50% and up to 100%, and it really depends on the circumstances. So, for instance, some of our clients have got these these large, particularly bulk retail tenants, and they store a lot of stock at the premises, so that would have an effect on what might be fair. You also need to think about what landlord costs are in this as well, and another consideration might be the extent to which the tenant can operate their business from elsewhere. So, for instance, law firms, we've got our firm's got 3 premises in Wellington, Lower Hutt, and Masterton, and we're operating remotely. A lot of businesses out there can't, for instance, restaurants can only operate from their premises. So again, that's another consideration. So it really comes down to what is fair in the circumstances, and it depends on each circumstance as to what's fair. And then on the on the flip side, some people are saying that if you can't access the premises at all, there should be an abatement of 100% of the rent. But again, it remains to be seen as to what will happen there. But I would say generally, I'd expect somewhere between 50 to 100% in rent relief if you have that clause in your lease. And and again, it just comes down to a case by case analysis and negotiation with between a tenant and a landlord. So that's all I'm going to say on cancellation and rent relief. But I think it's really important that we all remember that this current lockdown isn't anyone's fault. It's not the landlord's fault. It's not the tenant's fault. And I think we're just all looking for a fair. This is not legal advice, obviously, but we're looking for a fair outcome where the landlord's got to survive, but so is the tenant, and particularly the tenant is being particularly impacted. Their ability to generate revenue. The landlord obviously has the ability, once the tenant's back in business, to continue to charge rent, but I think it's really just a matter of contacting your landlord if you haven't been in touch with them already, and equally for landlords to contact their tenants and just reach out and just kind of work through things together. Both parties need to be aware that if you were litigating this or trying to enforce it, that involves cost, and the last thing you want to be doing is during these times is going through that process. So I would encourage everyone to try and work together and resolve it and come to an outcome that both parties find acceptable. And finally, I guess just a disclaimer that this is obviously, I've given you sort of a general overview of the position, but it's really important that you take your own legal advice, particularly in relation, if your lease has any amendments which affect these provisions affect, or you want some sort of guidance on what's fair. And there's all sorts of things that you need to consider, but I've kind of given you, I guess, a bit of a taster to start with. So, interested in any questions that anyone has. There doesn't seem to be too many questions. It's probably perhaps early on a Monday morning. But yeah, thank you all very much for tuning in, and we're more than happy to. I'm happy to take any questions. You can reach me on my my work number on the website. Perhaps early on a Monday morning. But yeah, thank you all very much for tuning in. So I've just got a question from one person asking what happens if you don't have clause 27.5. If you don't have clause 27.5, then unfortunately you're in the same position as someone with an older lease, which means the landlord is entitled to all of the rent and outgoings during the lockdown period.
There seems to be quite a big delay between the two platforms that we're using this morning, so apologies for that. And can I just say that thank you very much to Rhys Williams this morning from from Gibson Sheat. Gibson Sheat are a long-term supporter of the Hutt Valley Chamber of Commerce and are a platinum partner, and it's been fabulous to have them on the end of the phone over the last week to answer our questions. So thank you this morning for joining us, and we'll have another live stream tomorrow, and hopefully we'll have ironed out a few more of our technical glitches. Thank you.